at the Supreme Court this week. The Supreme Court upheld the resolutions of the Commission on Elections or COMELEC canceling Anwarai's registration as a party list organization. The court held that under the Constitution and the Party List System Act, it is the COMELEC that has exclusive jurisdiction to rule on the cancellation of party list registrations. The court also ruled that the cancellation was proper, as it was based on Section 6, Paragraph 5 of the Party List System Act, which states that violation of election laws, rules, or regulations is a ground for the cancellation of a party list's registration. The Office of the 2025 Bar Examinations Chairperson, Associate Justice Amy C. Lazaro Javier, issued Bar Bulletin No. 1, Series of 2025 on the conduct of the 2025 bar examinations, modality, coverage, schedule, and syllabi. Continuing on the reforms from the last 4 bar exams, the 2025 bar examinations shall remain digitalized and localized following a condensed 3-day examination schedule. You may download a copy of Bar Bulletin No. 1, Series of 2025 from the Supreme Court website. In another ruling, the Supreme Court said that the Commission on Audit, or COA, cannot expand its audit powers to include imposing administrative penalties. The court reminded COA that its conduct of an audit is not an exercise of the government's administrative supervision over public officers, as the COA's authority is limited to initiating the proper administrative, civil, and/or criminal action upon discovering a violation during an audit. The imposition of administrative penalties is outside the scope of its audit powers. Meanwhile, the court led the second leg of discussions on the proposed amendments to the Rules of Criminal Procedure in General Santos City on September 17, 2024. Among the proposed amendments to the Rules of Criminal Procedure are changing the term offenses to crimes to include crimes under special penal laws, using a certified DNA test result as a new ground for a motion for new trial, and giving to the Department of Justice exclusive jurisdiction to conduct preliminary investigation. The Supreme Court also sought input, suggestions, and feedback from judges and court employees from first and second level courts in South Cotabato, Cotabato, Sultan Kudarat, and Sarangani on the proposed new guidelines governing the conduct of judges and court personnel at the 5th leg of the Ethics Consultative Caravan held in General Santos City on September 18, 2024. Finally, the Supreme Court has ruled that in cases of rape committed by force, threat, or intimidation, it is not required to prove that the victim resisted. It is enough that such force, threat, or intimidation existed and was strong enough to prevent the victims from asserting their will, determined from the victim's perspective. The court clarified that previous decisions stating that a woman cannot claim to be a rape victim unless she resisted are contrary to current doctrine. The court stressed that the belief that if a woman does not resist, then she consents to the rape is unacceptable in any civilized society. This wrongly presumes that men are entitled to free access to a woman's body at any given time and place. The court said it is time to strike down such uninformed and ignorant views. And that's your Supreme Court this week. I am Tiffany Dobletran, Supreme Court Information Officer.